There are principles and laws that are in operation which are there for the benefit and protection for the individual. Law is the regime that orders human activities and relations through systematic application of the force of politically organized society or through social pressure, backed by force in such a society, which is a legal system. Within law, we find natural rights. All of us, you and me, men and women, we possess natural rights, and these are rights that are conceived as part of natural law, that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. So individuals have rights and freedoms. These rights and freedoms exist apart from legislative law or enactments. They are better known as natural rights, common law rights, fundamental rights and freedoms, or human rights, and they are not created by the government. They are natural human rights and fundamental freedoms. That are in operation for all of us to exercise and stand under. These rights and freedoms are not created by the government, but they are recognized by the government. Many of us are not aware of the fact that there are rights and freedoms that exist for us to use and stand under, which are not given or created for us by the government body. Mankind had already witnessed a tyranny of several dictators in the world's lifetime, men who caused strife and trouble worldwide. This strife and trouble led to several world wars, to the deaths of many, many millions and millions of individuals in the world. They witnessed destructive power that the government body can yield when it becomes too big and too powerful. The Universal Declaration on Human Rights, along with the subsequent International Bill on Human Rights, was introduced as a mechanism to be followed and used to prevent the outcomes of the past, to prevent any one government from obtaining authority and power over any one fundamental human rights and freedoms. Until this time in mankind's history, the law of the nation where the individual resided was to govern the individual. The domestic laws that were created bound individuals to obey their governments, even if the laws that the governments were creating were tyrannical, even if the laws limited or denied natural rights and freedoms. The more power a government had, the more it could subject its citizens and the individuals on the territory to submit to their laws. There was no mechanism available to speak back and to take a stand and to fight back. Now this would be changed by the implementation of the international covenants. This is where our rights as individuals become internationally recognized and become domestically recognized on our state party. So why does America, federal government, and state government in every subsequent state have the obligation to allow you to exercise your natural rights? America signed the covenant and ratified it in the year 1992. With reservations, the fundamental rights and freedoms, they pre-exist all. The International Covenant did not create these rights and freedoms. The International Covenants only recognize these rights and freedoms and place a legal obligation upon our countries, upon the governments of our countries, of America, Canada, and Russia, to respect our rights and not to limit our natural rights, and to make sure that their expression is found in domestic law. Now, these rights are brought forth through the United States Constitution, specifically through Article 6, Clause 2 of the Supremacy Clause. So this is the mechanism of law that they used, Article 6, Clause 2 of the Supremacy Clause, to bring into the international covenants and to the Constitution of the United States of America. And the obligation that was resting upon the government of America came directly from the International Covenant, Article 2, where it states, "Were not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant." Here is the legal obligation. There are rights and freedoms that are expressed in the covenant. There are provisions in the covenant, and your state party, America, have to bring these forth through the constitutional process. And you have to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So the legal obligation upon America is they have to give effect to the rights recognized in the present covenant, and they have to do it through a constitutional process, to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. The controlling medium is the international covenants. The rights and freedoms expressed in the covenants bind America, the rights and freedoms brought forth in the constitutional process, or through rights and freedoms. Rights and freedoms must be brought forth through the constitutional process. This is an obligation upon the United States. They have no choice. They have to do it. Further to this, in the international covenant, on civil and political rights, Article 5, it says, nothing in the present covenant may be interpreted as implying for any state, the United States of America, group, or person, any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. You cannot limit individuals' rights and freedoms apart from what the international covenant allows it to do. America and all state parties are under obligation to follow the international covenants. The covenants are the controlling mechanism that govern domestic laws. They cannot limit human rights and freedoms unless it is in accordance with the covenant. They cannot just make up laws and regulations that go against your fundamental natural rights. There always has to be a provision, a measure in place that allows you to exercise those inalienable rights. The obligation for them to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. The obligation comes out of the covenant itself. When we look at the article of law together, we see these articles of law produce the obligation on the executive powers of the USA. They must make provisions to give effect to the rights, and they must not take actions aimed at the destruction or limitation of the rights. Combining these articles of law together and then subsequently bringing forth the domestic applications, we bring forth clearly the picture, and that it must be done simply stating that this is an obligation without showing why is not a good enough reason. The U.S. reservations, declarations, and understandings concerning the International Covenant on Civil and Political Rights. It was the Senate's advice and consent subject to the following understandings, which shall apply to the obligations of the United States. Under the covenant, that the United States understands that this covenant shall be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over the matters covered therein. So there is the obligation through your own constitutional act. It says the federal government has the obligation to respect and implement this covenant, and otherwise by the state and local governments to the extent that the state and local governments exercise jurisdictions over the matters. So if it is a state regulation or enactment, then the state has the obligation to respect your rights. If it is a federal enactment, then the federal government has an obligation to respect your rights. Why? Because they have to implement this for the fulfillment of the covenant. They went ahead and they made reservations. The Senate's advice and consent is subject to the following declarations: that the United States declares that the provisions of Articles 1 through 27 of the Covenant are not self-executing. So they said, yes, we have the obligation to respect and implement your rights, and this obligation falls upon the federal government, and it falls upon the local government, and we will do our part to fulfill the covenant concerning your natural fundamental rights and freedoms. But these rights and freedoms are not self-executing, so it is only when you approach the executive powers, the government, and say, I have certain rights and freedoms under Articles 1 through 27 of the Covenant. More than that, they are not self-executing. I am here before you seeking to exercise my rights, looking back into the International Covenant on Civil and Political Rights. On Civil and Political Rights, Article 2, where that obligation comes upon America, and it states, were not already provided for by existing legislative or other measures as may be necessary to give effect to the rights recognized in the present covenant. So when we look into the covenant and domestic laws of the United States of America, we're going to find that some of the rights and freedoms that are expressed in the covenant had already been expressed in American domestic law prior to their obligation falling upon them. If the fundamental natural rights and freedoms that are brought forth in the covenant do not exist in America or Canada or any other state party, the executive powers of the state is under the obligation to provide operations of law to enforce these rights. When we look into the state constitutions in any state, we will find that the constitutions are bringing forth the operations of law that respect our common law rights and fundamental rights and freedoms. There is provisions and mechanisms of law available for the individual to enforce their rights. The provisions flow out of international law, the International Covenant, through the Constitution Acts, and subsequently into the justice system, through the judiciary, through the administration of justice. This is how you would seek your rights. The state party, the Superior Court of the United States of America, are under obligation to take judicial notice of your natural rights and freedoms and protect them. They have the ability within their courts to produce a remedy for a violation against your inalienable rights. Now, when you look into the Constitution of Indiana, Section 12, it states, all courts shall be open, and every person for injury done to him and his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely without purchase, completely without denial, speedily without delay. In each state constitution, you're going to find a section that deals with this specifically. It's going to state that the courts are open and you can use the court to enforce your right, to enforce the law. It's going to tell you that the courts are open to every person. It's a general statement, and when you look at the word person, we understand that the word person can mean a man or woman or the artificial. This operation of law is present in every constitution, and there is an indication that we are able to have a remedy for a violation of our rights. The courts are open to us to use to seek remedy against the limitation or denial of our rights. The Constitution, whether federal or state, they acknowledge and respect and guarantee us the exercise of these natural common law, fundamental rights and freedoms. Looking at Constitution Act of Canada, Article 7, it says, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except to a principle of justice. Florida Constitution in Section 2, basic rights are natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life, liberty, and pursue happiness. When you look at the Constitution of California, Article 1, Section 1 says, all men are by nature free and independent and have certain inalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. The Constitution of Illinois, Section 1, all men are by nature free and independent and have certain inherent and inalienable rights, among which are life, liberty, and the pursuit of happiness. To secure these rights and the protection of property, government are instituted among men, deriving their just powers from the consent of the government. What is the purpose of government? The purpose of government was to secure these rights. Which rights? Our natural rights. The primary purpose for government was to protect our natural fundamental rights and freedoms, and to allow us to express them and to operate them, and not to interfere through a commercial capacity.